Hey everyone, it's Braulio Rosa with the Broward Bar Buzz. I'm here with Ross Abramowitz, a friend and founding partner of the injury firm. And today we're going to discuss really the state of the practice, legal practice, really looking at the civil side. Welcome, Ross.
Thank you for having me. I always come bearing gifts. Last time I made us dress up in costume. My wife now made us some homemade trail mix, very spicy.
It is very spicy. You warned me. I tried it, and it's delish, but definitely spicy.
It's the fall. Apparently, that's our fall move.
I may refrain while we're doing
That's
this so
fine.
that I'm not sitting there going. But anyhow, yeah. Look, recently we've had this tort reform and a major change. Give us that 30,000 foot perspective on really what's going on with lawyers and how it impacts lawyers and the courts and clients, really.
We started this new reality. And the new reality now, as you mentioned, I'm managing partner of the injury firm. And we, at the time, were already pivoting into litigation more than pre-suit because we saw the writing on the wall with the insurance company offers, and we knew that that's kind of where the cases were going. So our firm was getting ready for it. Since that time, I think we went from 4 litigators. Now we're talking 7 months. We went from 4 litigators in our litigation department to 9 litigators now. Just to show you that, I mean, equates to almost 1 litigator hired a month.
Can you explain why now there's more litigation instead of prior to this change?
Yeah, so there's a bunch of reasons. The one main reason that obviously everyone knows about that is a practicing attorney is we all had to file lawsuits prior to the change in law because it was our belief, and it's still being argued in the courts, but for most of the opinions it's coming down on the plaintiff's side's view, that if we filed it before the law changed, before the tort reform took place, that we would have the use of the old laws and the old rules, which Debbie went into depth about. And because of that, all of these lawsuits were filed. And now they all had to find a home, and they all had to find a way to practice. Now, a lot of the firms that filed these lawsuits were pre-suit firms. They didn't really know what they were doing, but they knew they had to preserve their client's right. And so then they would call us up, a slightly larger firm, and say, hey, could you help me with this? Can you help my client with this? And we would sign up the client, and that's where we are right now, where all of these files that were never, I mean, I would argue to say that, at least in the personal injury realm, the courts have never seen a filing like they did because of this tort reform. And the aftermath, like I said, is our firm and other firms have hired at least 1 litigator a month to deal with this. And all of the offers now that we're seeing from insurance companies are much lower, which is pushing everything to litigation. The new big picture of cases in personal injury are litigation cases. They're not so much like, oh, when it used to be 60% would be settled pre-suit, 40% would be in litigation. Now it's even worse. It's not even flipped. It's more of like you could probably settle 35% pre-suit and the rest go to litigation now.
Why are insurance companies not settling? What's their strategy behind this?
It's like anyone else. We want to make money. They want to make money. I think that they are testing the new reality, and they want to see where things are going. They want to say to a pre-suit firm, hey, you need to file to get money. Or they want to say to us, hey, you need to staff up. You need to hire more in order to get where you need to be to get the right result for your client. My partner and I, Paul Gallister, we have taken the approach of hiring attorneys. Some firms like to hire paralegals, and they are light on the attorney side. As we're seeing things head into litigation, we believe personally that the attorneys are the people that steer the ships, and therefore we need more attorneys on board to make these decisions, to make cases move faster, to make them move more efficiently for the judges. I think that's one other thing we talked about were judges. This is a new reality for them, just as much as it is for us, just as much as it is for the insurance companies and defense attorneys.
Wait, but before we go there, I was
Yeah.
just thinking, do you think insurance companies, they're wanting to take it to trial because they want to see ultimately how much money you're actually going to get, to kind of test, like you say, like before the law change, you knew that you probably could get about this much, X amount with your experience of doing this. Now it's a different world. So I'm wondering if they're just trying to test, like, are they going to actually get what they're asking, or what percentage less?
I think we're going to see that. The courts are bogged down with all of the older law cases, the pre-tort reform cases. So those, in my opinion, are going to stay the same. They have to try all those cases that we filed. It's going to be years before we see a new case go, based on order of filing, go to trial. So that'll be down the road. I do think that they are testing us now to even take it, past certain milestones, whether it be depositions or mediations, to see how far we'll take it in order for them to put real money on the case. And from, like you said, above the surface viewpoint of this, that's where everything's going. And hopefully our clients will understand that, be more patient with the process. The judges obviously see that coming, so they're more patient with the process to a certain, as much as they can be, based on the orders they have to follow with the Florida Supreme Court. That throws another wrench into the whole process. As of last year, when they came down and said, hey, we need to move our cases faster, we need to clear our dockets faster. And I understand that point as well, but you add tort reform onto that, kind of creates the perfect storm for, working as hard as possible to get the right result, but at the same time having things fight against you.
So with the tort reform, and then now here in Broward, you've got this pool we're talking about.
Yes.
And explain that quickly.
So I'm not very familiar with it. We were talking about it from a first-party property perspective. And they created this pool because they want cases to be tried faster. And so they brought in, and again, I'm not 100% familiar with it because I haven't come on the pool.
But that's not impacting personal injury folks. That's just...
No, not necessarily. They're more along the lines of first-party property cases. There's a lot of insurance companies that want to try these cases. Citizens being the main one, which is obviously a state-run insurance company.
Because your judge can switch, right? It goes in this pool and suddenly...
Well, that's what happens. Yeah, it goes into a pool, and you have a lot of people want to do that because they want to get their case to trial. They just don't want to keep getting rolled over and over and over again. The client wants to get to trial, so they're willing to roll the dice with whatever judge they get, as long as they can get a trial. And for what I've heard, I mean, obviously all the judges that are doing these pools are more than qualified, and I've heard only positive things about the pools. But like you said, it's more along the lines of, I believe, the first-party property cases, not so much the personal injury cases yet. So, that has been one aspect of change in our practice. The other interesting thing I've noticed is it used to be back in the days, let's say 10, 15, 20 years ago with Schlesinger, Kelly Ustall, those kind of firms, that there would be attorneys that would go to those firms and they would refine their skills, right? They would grow with the firm, and after a certain amount of time, after they've tried a lot of cases, they would then go on their own. And they would be legitimate trial attorneys, and they are who we know them to be today. I mean,
right.
they're pillars of our community. What I'm noticing now is all of these attorneys that are coming out of law school and jumping into firms like mine, jumping into other firms, they're getting the experience on these, volume of cases. Not necessarily trying a case, but then going out on their own. And so you're having a lot of solo practitioners pop up. You're having a lot of, just smaller firms being formed with two associates from another firm. And that's kind of a new look to the field that we didn't necessarily see before. All of these solo practitioners or smaller practitioner firms popping up with, smaller caseloads, trying to get out their market and build. And look, I've had 2 or 3 of my attorneys go out on their own. Was more than happy to help them, send them cases. Happy for them. That's how I started. That's how everyone starts their firm.
Right.
But I just find it interesting that the idea of like honing your skills with bigger firms and learning from the partners kind of has gone by the wayside. I don't know if it has anything necessarily to do with tort reform, but it's just the reality of the litigation and the reality of just the practice in general right now.
I wonder if it's a generational thing. I don't know.
Could be.
I'm thinking sociological or something. You have a new generation, and they don't want to wait. They want it right now.
Yeah, that could be.
Versus like our generation that was kind of like, put in your dues, work hard, put in your dues.
Yeah, more of a allegiance. I don't want to put anyone down
No,
for
it's
doing
not
it.
being negative. Hey.
But it's more of allegiance to the practice and the, I guess what was instilled generation ago is work for the person that gave you the opportunity, and then when they then give you their wishes, you can then go out,
Right.
rather than, oh, let me learn a little bit and then I can do better, or I can go out on my own. And again, the people that have went out from our firm, we only have great relationships with them.
Yeah.
Great people, great members of the Broward County Bar, and it's just an interesting difference. Like we were just talking, how things are shifting. That's another way the profession is shifting.
Seems like there's more and more younger attorneys breaking out, not just in personal injury, but in other areas, and kind of just hanging their own shingle after a very short period of time.
Yeah.
Agreed. I don't know if there's always going to be big law, but it seems like there's less of it. I don't know.
Yeah, I mean, that's a perfect way to look at it. A lot of the firms that I had mentioned and other larger firms now are, the main partners are getting older, or they want to more hone in on specific types of personal injury or specific types of law, rather than, grow their firm. And that seems to be where everything is headed as well. The firms like my firm, where we take on pretty much everything but medical malpractice, the smaller firms and even the bigger firms that are older are now starting to say, like, okay, we're going to specialize only in medical malpractice. We're going to specialize only, and there are plenty of firms around this area that are doing that. So that makes it interesting.
How is people breaking out on their own, and this the stress of the practice now? We were talking a little bit about that. How does the mental health side play into that?
Great question. That's something that concerns me. It's an ongoing thing. This tort reform, like I said, we're 7 months in, a little bit over 7 months in, and it really concerns me. All these lawsuits were filed, right? All at the same time, which means they all have to be litigated at the same time. And you have attorneys coming into my firm, into other firms, and I'm saying, hey, you want to learn this, we're ready to teach you. Here's 25, 30 cases, 40 cases. The problem is they're all filed at the same time, so they have to move them all at the same time. That wasn't the case ever before. It was, here's two, here's two, here's two. They were all spaced out. So you could see, now it's all at once. File discovery all at once. File answers all at once. And it's a lot for new attorneys. Not even new attorneys, 10-year attorneys, 15-year attorneys. It's a lot for these attorneys to be able to handle. Not everyone has the mindset of like organization and all that. Some of them struggle with organization. And when you're struggling with organization and you're handed 25 new cases that you have to run, your hands go up. You say, I don't really know what to do here. Yeah. And I think a lot of people are struggling. I think a lot of people will struggle with this. Obviously I'm grateful to be able to be part of the Bench and Bar Association, and we talk about that in these meetings. I think it needs to be talked about more. One other thing that I guess you brought up is these people going out on their own. And they're going to face this. And I think that law office management has to be focused more in law schools, because a lot of these attorneys going on their own are 1 year, 2 year, 4 year attorneys. Like, they're not very far removed from law school. But that's not a course, at least from what I went to law school, it was a while ago, but that was not a course that was harped on or even made mandatory. And I honestly believe with where the law is headed, where personal injury law is headed, that needs to be made mandatory so that they have that bigger perspective of, this is when I make that move, because I'm going to do it, I know that I have to follow this playbook.
Right.
They don't know the playbook.
Well, it seems that in law school, and I get why, it's they really focus on the practice of law,
Correct.
practice of law. It's a profession, and it is. But what they forget is that there's another part of it, which is the business of law. And because you can be an amazing lawyer, and I guess if you're happy working for someone forever, then that's okay. But at some point, maybe you want to open your own practice, be your own boss. Well, that's a whole different skill.
Yeah. And that's where we are now. I mean, again, I've said it multiple times, but that's the reality of what our practice is turning into. Everyone wants to get their feet wet. And if they're doing it earlier and earlier, like I'm seeing with some of my attorneys, they need to have the framework. And like you said, they're being taught to practice. They're not being taught the business of practice. And I believe that's something very important that hopefully with us, with the judges in the bench and bar and with some of the other attorneys that have a lot more clout than I do, they can go back to the law schools and start going in that direction to give them the framework.
It.
You want to take a phone call?
No. It seems like a perfect soup for potential malpractice for lawyers that don't have experience, maybe misfiling, whatever. I mean, those are basic things, but it's possible they don't have someone over them making sure that they're crossing the T's, dotting their I's.
Yeah, it's definitely possible. I'd like to take more of an optimistic look at it and say, hey, they're going to reach out to the bar. They're going to reach out for the CLEs. So whatever questions they have, they can get answers. But like the reality of it is once they get thrown into the day-to-day and they have to cut the trust account checks and then they have to flip over real quick and deal with a deadline for a filing, and then they have to deal with a trial order, and then they have to schedule things. They're going to they're going to start missing things. And when they start missing things, once you get overwhelmed, like we were just talking about with mental health, everything starts spiraling. Yeah. And you don't want to see that with one person, yet alone like a practice like personal injury where everything is go.
Yeah.
So
and the biggest part, I'm on a grievance committee, and some of the big no-nos that you see come through are put aside the trust account. That's an obvious.
Yeah.
But not responding to your clients.
Of course.
It's a big one.
Yeah. And again, when you're taking over, when you're filing so many cases like we all did, and now you have to hire an attorney who's new and is handling 25, 30, 40 cases in litigation, it's really easy to forget some of these cases, some of these clients. And they call into the office and you might be at lunch, or now you missed their call once, you missed their call twice. You go on vacation, medical leave, and you don't properly notify them. Now you're dealing with that. And like that's something that you don't want to see for anyone, especially so when dealing with a medical issue or a personal issue. Like you don't want to see them have to come back to bar complaints or come back to, but that's, where I don't want to say that's where the practice is headed, because I have more of an optimistic look, but people that are coming out, opening their own firms have to be very, very careful and understand that that is a reality that we are living in today. This isn't something coming up. This is something we are living in today.
Right. And for those young attorneys, they should realize, and I'm sure they do, but just in case, that to you, maybe this case isn't that big of a deal, but to this client, this is the most important thing in the world. The only reason people come to see an attorney, for the most part, is they've got a problem.
Yeah.
And you're this person that's trained that can help them, and they're looking for you to help them. And now you sign them on and you're blowing them off.
One good point also, to stick in the personal injury, the plaintiff side of things, is, we as attorneys look at furthering our practice, making money. And with that, we have to look at policies and seeing the value of the case. And newer attorneys that are coming on, or people that are opening their firms that might be 4 or 5 year attorneys, you have to not be blinded by this case is only worth X because of that policy. This case is only worth Y because of the coverage that store has. And you have to realize that each case has a different injury that you have to respect, and you have to respect that client, even though their case might only be worth $10,000 when the other case you have is worth $100,000. And that is very easy to get blinded by as well. Very good point that you brought up. And you have to treat them all evenly, and you have to give them the same attention. Yeah. And then it's up to you to make the decision if you want to take those certain cases. We're a firm, Paul and I built a firm that takes everything from the smallest case to the largest case. And we treat them all equally, and that's why we hired so many attorneys. Because we want to make sure that it's attorney-based, that they're getting the phone call back, or they're getting answered right away by an attorney, rather than a paralegal or a legal assistant that might not have the answer they're looking for.
Right.
And that's a reality as well, that, as the insurance companies are taking the benefit of this tort reform, they're starting to see, hey, we can really write lower policies. We can put language in our policies that doesn't protect the insured as much as it should. And I know, I mean, it is what it is. I mean, we are fighting an uphill battle right now in the courts, in the legislation. Big business has definitely gotten a benefit this past year, and we're just trying to fight back to even the playing field, help our clients and help the profession in general. Because we want this profession to be around for a very long time, and we want people to have an avenue of redress for their injuries. Hopefully, as we move through this, the courts, the attorneys, the mediators, I mean, I go on, that we all get on the same page with how to handle the Supreme Court orders, how to handle the trial orders, how to handle the clients, and we can move these cases faster and again, focusing on mental health, making sure everyone's health, not only our clients, but our own, is taken care of.
So I know off camera we were talking about in your 15 plus years of being an attorney, you hadn't seen something impact the practice of law so much like this tort reform. Do you see any ray of sunshine that there's some hope out there that
There's
things
always
could
hope.
be rectified?
I love the word rectified, because you're like, how do you change what you have? I mean, obviously it's going to take a lot to change it. I think the better outlook, the way that I rationalize it in my head, it's funny, last summer I thought that after practicing for so many years and building what we have now at the injury firm, I was like, I'm going to take off 2 or 3 weeks, be able to be with the kids over their summer break. And then this hit in March, and I couldn't even tell you where the past 7 months have gone. Yeah. And so I'd like to
running
think that,
your firm.
Right, exactly. But I'd like to think that using rectifying the situation is getting back to more of a reality of, the cases are being filed more distantly. The demands of the trial orders and the demands of the Florida Supreme Court orders are being spread out more evenly. The cases are being tried in a fashion that allows an attorney to actually get some rest. All of those things would help towards going in the right direction. Would I like for the judiciary and the legislature to change some things? Of course, but that doesn't happen overnight. And this is what we're dealing with. This is the reality of things. And if we can fix these things little by little and bring some semblance of relaxation along with the work, that will make things a lot better. Right now, and you can ask pretty much any litigator out there that's doing personal injury, there is no relaxation in between cases. It's case after case after case, trial order after trial order after trial order, and that is, for the next foreseeable future, the reality of this.
The plaintiffs' bar is Florida Justice Association.
Yeah, Florida,
right?
yes.
Are they doing anything about this?
They are. We're handling it the best way we can. I used to be the president of the association. I think it's back to the Florida Trial Lawyers Association. I never remember if one or the other.
The state, I know they lobby at the state level.
Correct. We lobby at the state level. There's other organizations that obviously are bigger than our organization that lobbies at the state level. Right now, we're just trying to organize the fight, trying to organize the orders that the judiciary is putting out in order to fight some of the issues, like retroactively applying the tort reform. That's a big fight that, again, I believe Debbie, you said Attorney right. Debbie, right? That Debbie mentioned. The retroactive application of these things now would severely impact, negatively impact a lot of these injured
That's what they're trying to do, right? Some of the judges?
Not the judges. The defense attorneys are arguing it. However the judge interprets it, I don't want to say the judge is doing anything wrong. However they interpret it might be affecting it. Luckily, we have a wave of cases in our favor that have stopped that retroactivity. But the fight is still going and is just starting. So as long as we're united, which we are, I see only positive coming from our end in moving forward and like I said, just trying to rectify some of the faults of this tort reform and some of the issues that we're having with some trial orders and moving cases a little bit too fast for the life of the case.
Peace.
So
Tough times.
it's tough times, but there's always positive to it. Yeah. Our profession is here. There are some other professions that unfortunately were also decimated by the tort reform who really can't practice anymore. So the personal injury field is here to stay. There might have been some roadblocks and some speed bumps put in our way, but I'm confident that we are going to get around that. I'm confident we're going to get just results for our clients, even if it means litigating every case to the end. And like we just talked about for however long we've been talking, that seems to be the direction it's going. And we'll just hire more attorneys, and more attorneys are going to open their own firm and do this and litigate these cases for the injured parties and hopefully get the right results. But again, as much as it was doom and gloom we were talking about and the spicy Chex Mix here.
I was like, okay, I had one, and I'm like, okay.
That's it. I do see a lot of positives in the future, and hopefully we can have more of these talks where I can come in here in the near future and say, hey, some good things happen. Here, let's talk about those good things and talk about how these cases are getting spread out and mental health is at the forefront.
How does someone get a hold of you if they need to contact you?
You could reach out to us via phone. The injury firm is also easy to remember, so you can look us up, flinjuryfirm.com. Phone number super easy, 954-951-0000. Ross Abramowitz, that's me. You can look me up on the bar. You can look me up online, and we'd be happy to help any clients that were injured in any kind of accident, whether it's slip and fall or car accident.
Awesome. Well, I look forward to inviting you back, hopefully over the next couple months, to see how this is evolving, my friend.
Yeah, that'd be great. I appreciate it all the time. You're doing a great job with the setup here. Just getting better every time I see it. So
we try. Be well.
Thank you.